Good morning, everyone. Thank you for joining us today. This is our second series of webinars hosted by the Gunster Environmental Law Practice Group, and we're happy you're here with us today. So today's webinar, as you can see from the screen, Understanding the Impact of the Trump Executive Orders. What we're hoping to cover today is a little bit more background on the many executive orders that we have been seeing coming out of the White House, the earliest one on January 20th of this year. And so we're going to take a bit of a dive into these executive orders and give you some background on what they mean, what impacts we're seeing them having in Florida and elsewhere. But before we get started, let me introduce our panelists. My name is Luna Phillips, and I'm going to be moderating this webinar, and I head up the Environmental Practice Group here at Gunster. And with me today is Phil Sliger. Phil is an attorney in our Environmental Practice Group, and he's been practicing since 2022. His practice focuses on a broad cross-section of issues, including wetlands, waste, energy, air, sovereign submerged lands, and he's going to be discussing the environmental and the administrative executive orders today. Next, we have Debbie Madden. Debbie's a partner in our environmental practice group as well, and she also focuses her practice on a broad range of matters. She has specialties in listed species, ERP, and due diligence, and Debbie was an environmental consultant before attending law school. And next, we have Alex Kiernan. Alex is a senior advisor and policy leader with our firm's newly created Government Affairs Aero Group. She has over a decade of experience advising clients regarding Florida's legislative and governmental matters. And also prior to joining Gunster, Alex served as the Director of Legislative and Government Affairs at DEP. A couple of housekeeping points before we get started. If you have questions, we are going to take questions at the end of the webinar. We'll leave about 10 to 15 minutes, but feel free to put your questions in as you think of them. There should be a button on your right side of your screen with a question mark, and we'll track the questions and try to make sure we get to as many of them as we can. And then also the webinar was approved for Florida Bar CLE credit for any attorneys that are joining us today, and we'll provide the CLE number at the end of the webinar. So just to kick us off, I wanted to give a little bit of background on what an executive order actually is, because we do get a lot of questions from our clients as to what are these and why are they being used as much in this administration. And as many of you know, Article 2 of the Constitution is what gives the President of the United States executive power over the government to take care of laws and make sure that they're executed. So the President has been relying on this provision of the Constitution to issue the executive orders that we're going to be discussing today. And generally, executive orders are used to carry out policy priorities, directing agencies to implement a certain rule or regulation, or even review rules and regulations that are in existence. But there are limitations or checks and balances on how executive orders can be used. And at the core, an executive order cannot create or alter a law that has been passed by Congress. So there are some limitations, and those are some of the things that we'll get into the discussion today. So with that, I'd like to turn it over to Phil, who's going to start us off by discussing the environmental and the administrative EOs. Phil? Phil, you may be muted. Bear with us, folks, for one moment. I don't know if others are having trouble hearing Phil. Okay, well, while Phil works on the technical issues with the microphone, we will transition to Debbie Madden. And Debbie is going to be discussing the effects of some of these executive orders.
Yep, glad to. Thanks, Luna. We've seen several notable effects from these executive orders. Phil will go back and fill you in on the details, but one of the main important executive orders was the Unleashing American Energy executive order, really directing the EPA and many other agencies to look at their policies. And so we've started to see the agencies reacting to these executive orders, putting out their agenda for what they'll be doing in response. And then also I'll briefly touch on, there's been some significant reaction from third parties in the form of lawsuits challenging the executive orders. And the executive orders have also given the agencies some breathing room in their litigation that's existing to reconsider their positions. So about 60 days after the Unleashing American Energy executive order, EPA announced its deregulatory agenda covering a broad range of rollbacks aimed at boosting energy production, among other things, and emphasizing a return to cooperative federalism, which basically means putting the emphasis on the states having more control in regulating environmental matters, which makes a lot of sense for a state like Florida. One example of a lot of activity recently in March was the subject of the waters of the United States. And I'll remind everybody that waters of the United States is the foundational term in the Clean Water Act, that any water that is a water of the United States is covered by the Clean Water Act. And so filling them requires a 404 permit, or discharging into them requires an NPDES permit. And EPA and the Army Corps of Engineers started rolling out their policy through a new guidance memo that's effective immediately, and it clarifies the meaning of continuous surface connection as it's related to water adjacent wetlands in the definition of waters of the U.S. And this guidance is significant because it rescinds previous guidance and training materials that had interpreted continuous surface connection as being established through a discrete feature like a non-jurisdictional ditch, swale, pipe, or culvert, and that is now changed. There must be a continuous surface connection, and those discrete features actually sever that. So, and then in furtherance of a more durable rulemaking solution, EPA and the Corps issued a notice in the Federal Register outlining the process to gather stakeholder recommendations on defining other key terms that came out of the Sackett opinion, the US Supreme Court opinion. So EPA is acting quickly there. Also, another notable response to the executive orders is the Council on Environmental Quality, or CEQ. They published the interim final rule rescinding CEQ's NEPA regulations. Those regulations were 40 years old, based on an executive order that the Trump administration finalized this year, revoking the President Carter era executive order that directed CEQ to issue those regulations. So we do expect that rule will be finalized in April. It will go final because it was an interim final rule, although they are accepting some comments on that. And then not only are the CEQ regulations affected, each federal agency has its own NEPA implementing regulations. And in response to the Unleashing American Energy executive order, CEQ published a memorandum to the heads of the federal agencies, asking them to provide guidance on implementing NEPA to expedite and simplify the permitting process. So those agencies were directed to review and revise their NEPA regulations within 12 months of that memo. So very quick action there by those two agencies. I also mentioned the litigation topic. Many of you may know there were numerous existing lawsuits challenging rules that were enacted during the Biden administration, and consistent with the direction in the executive orders to review the agency's regulations and litigation positions. Several agencies, including EPA, have filed motions to stay these cases or hold the cases in abeyance while this review goes forward. And so we've seen these stay requests granted and expect that the agencies will be developing positions, consistent with the Trump administration's new policies. And so as those positions play out in the courts, it's not exactly clear how the court cases will turn out if the agency determines that they don't want to defend those rules based on these policy shifts. And one other thing worth noting, several court cases have been filed challenging the executive orders themselves. A couple challenges on environmental topics, including, for example, the reopening of the outer continental shelf for oil and gas leases. And the Trump administration has responded with a move that might disincentivize these types of requests for injunctions. You may have heard that the Trump administration announced a new policy just recently that the Justice Department attorneys enforce an existing federal rule of civil procedure. It's Rule 65, and they're requiring the government attorneys request that the court require plaintiffs who sue the administration and get an injunction that they post a money bond, a security, to cover the government's costs if those injunctions are overturned. So that development could rein in the number of legal challenges that we're seeing.
Mm-hmm. Thank you, Deb. I appreciate that. I just want to check and see if Phil's mic is now working.
I believe so, testing.
Okay, great. Glad we got that resolved. So Phil, I'll turn it over to you so you could give us a little bit of background on some of the executive orders that Debbie touched on.
Sure. Apologies for taking us out of order a bit here, but I'm sure for those of you that follow the news have noticed that the administration has been very busy in its first couple of months in office with regard to taking executive action. Has issued a flurry of executive orders to define the policy priorities of the administration and to give direction to the administrative agencies on how to implement those priorities. So we'll discuss a handful of those specifically as they relate to the administration's environmental policy and some aggressive goals as it relates to deregulation. Among the first executive orders that was issued was simply to rescind more than 75 executive orders that were issued by the prior administration. So these rescissions targeted policies and resources that had been established for things like environmental justice, combating climate change, implementing the Green New Deal. Another early executive order, which Debbie touched on, was Unleashing American Energy. This order broadly established the administration's energy policies, which include domesticating energy production, eliminating what it refers to as the EV mandate, and ensuring that all energy-related regulations are grounded in clearly applicable law. So as part of that latter requirement, the order did direct agencies to review their existing rules and their guidance documents to ensure consistency with the administration's new energy policies and to ensure that those regulations don't pose an undue burden on domestic energy resources. Additionally, the order directed agencies to work with the Attorney General to review any pending litigation that involves agency rules that might be subject to review under Unleashing American Energy. The executive order does impact more than just the energy sector. For instance, the order included direction to the Council on Environmental Quality to consider rescinding its NEPA regulations. And as Debbie mentioned, CEQ has already begun the process of this through an interim final rule to rescind those regulations. It also directed CEQ to provide guidance to other agencies that implement NEPA and instructed those agencies to revise their regulations with the overall goal of streamlining and expediting the federal permitting process. Another executive order of note was the regulatory freeze pending review. this order directed the withdrawal of all pending regulations that had not been published in the Federal Register when the administration took office. It also prohibited agencies from issuing new regulations until a Trump-appointed official could review and approve them. Agencies were also directed to postpone the effective date of any pending final rules for 60 days to review those rules for consistency with administration policies and for any facts of law policy or any fact, law, or policy that those rules might raise. So collectively, we have rules that were pending when the administration took office, any regulations that might conflict with the administration's broad energy policies, as well as NEPA implementing regulations. And between all of those, there's some significant environmental regulations that are presently subject to review under the current administration. In addition to that, there have been a number of executive actions that reflect the administration's deregulatory goals. For instance, a hiring freeze for administrative agencies that prohibits the filling of any vacant positions or the creation of any new federal government positions for 90 days. And in that same period, instructs the Office of Management and Budget to submit a plan to reduce the size of the federal workforce through efficiency and attrition. Also, there was a 10-to-1 deregulation order that requires that whenever an agency promulgates a new rule, regulation, or guidance, it must identify at least 10 existing rules, regulations, or guidance documents to be repealed. This order would also be carried out through the Office of Management Budget through a plan that establishes standards and measures for the reduction of regulatory costs. So just to kind of summarize all of that, the early executive orders have the effect of establishing some aggressive deregulatory goals for the administration. They also identify some broad categories of rules that the agencies must review in accord with the administration's policies. Now, as far as the legal effect of these executive orders, the president does have the authority to revoke or modify prior issued executive orders at any time. So the orders that require rescission of prior executive orders are effective, and any agency policies or programs that rely on those rescinded executive orders would be vulnerable to legal challenge on that basis. In addition, administrative agencies have the authority to withdraw their final rules at any time prior to publication in the Federal Register without undertaking notice and comment rulemaking. So the administration's orders in that regard also appear to be on firm legal footing. However, the vast majority of the administration's environmental and deregulatory policies cannot be implemented by an executive order alone. For instance, to withdraw existing rules would require the administration to undertake formal notice and comment rulemaking under the Administrative Procedures Act. This can involve the development of a substantial administrative record, can involve protracted timelines, and ultimately at the culmination of that process, there's an opportunity for legal challenge. So the formalities required under the APA present a potential hurdle for the administration as it tries to effectuate the policies in its executive orders, and ultimately may add to some of the uncertainty for the regulated community as that process plays out.
Thank you, Phil. I had one follow-up question for you, and you were talking about the legal implications. So, for the lawyers that are on the webinar, we've been tracking the recent Loper-Bright decisions and the changes in agency discretion. What are your thoughts about how those cases might affect the executive orders and the agencies revisiting their regulations?
Yeah, and I think it's very likely that many of the policies that are put into effect by this administration will ultimately be subject to legal challenge. I think to remind folks of what the Loper-Bright decision was, it overruled the prior existing Chevron doctrine, which gave administrative agencies the flexibility to interpret statutes such that a new administration could interpret a statute to justify a different rule based on their interpretation of the statute. With Loper-Bright overturning that, for lack of a better term, the game is for keeps now. The interpretations of statutes will be a judicial decision that will be a little bit harder to overturn. So as some of the new administration's policies make their way in front of a court, that deference that previously used to be afforded to administrative agencies is no longer there, and the ultimate judicial conclusions will be less subject to sort of the ping pong back and forth that we have historically seen on matters such as waters of the United States that Debbie touched on.
Excellent, thank you. Debbie, I wanted to follow back up with you. We've been discussing a lot of these executive orders, and I wanted to get your thoughts on how do these executive orders, and what are your thoughts on how this is going to affect Florida businesses, and what does it mean for us here in Florida?
Yeah, thanks, Luna. I think the key point, with one exception, is that almost all of the executive orders are focused on the administration's agencies, and they require further action. So despite what's sometimes misreported in the media, most of the executive orders direct the agencies to consider or review or reconsider certain actions rather than directing a specific outcome. For example, EPA was directed to reconsider the endangerment finding that enabled much of the greenhouse gas regulations over the last 10 years plus. And so that, that's not a done deal. It has to be reconsidered by EPA. And then also another example that we've touched on is the review of the existing regulations for compliance with applicable law. And that was used as a springboard for the Waters of the United States review that we touched on. So, much of what's happening is going to be worked out by the agencies over time. And as Phil mentioned, these agencies must enact regulations to put the executive orders into effect. And that might involve repealing or replacing previous regulations, which is something we saw in previous administrations. And to do any of these things, in enacting a new rule or repealing past regulations, modifying existing regulations, the agencies go through traditional notice and comment rulemaking. So following these executive orders, you can expect proposed rules, followed by a comment period, and then following that, a final rule. And recall that unlike in Florida, federal rules become effective when they're finalized, even if they are challenged and litigated. So, and I think, you can bet that most of the rules coming out of the EPA deregulatory agenda will be litigated, which this process leads to a question for many of our attendees' businesses. How long do I have to comply with the old regulations while we wait for the new regulations to be finalized? We look back at a couple of examples for timeframes, and for example, the previous Waters of the United States regulation changes. In the first Trump administration, it took 2 years and 9 months to repeal the Obama administration's Clean Water Rule. And also it took 3 years and 3 months to finalize the Navigable Waters Protection Rule. That was a 2-step repeal and replace effort there. And then another example was on the greenhouse gas regulation. The Biden administration took 2 years and 6 months to repeal and replace the Affordable Clean Energy Rule with the Clean Power Plan. So all that's to say is it's not overnight to get these new rules promulgated and in place. And even if the administration works quickly, the period of continued compliance with the old rules would likely be measured in years instead of weeks. But in the meantime, there are things that the administration is doing that would are worth noting. We have to be on the lookout for guidance documents like the EPA guidance on the waters of the US that we mentioned, which eliminated the use of the discrete features like ditches to connect adjacent waters to waters of the US. And things like that can provide some immediate help and clarity while the agency finalizes a new rule. We're also looking for statements extending compliance deadlines or providing an off-ramp for compliance while new rules are finalized. So you may see rules with existing finalized rules getting new compliance deadlines. And then the durability of these compliance extensions and guidance documents, it's not as good as a full notice and comment rulemaking, but it can provide a bridge from those old rules to the new rules based on new policies. And then just circling back on one point, I mentioned that there was one exception that most of the executive orders would require rulemaking to make the regulatory changes, but the exception to that is the executive orders that abolish previous executive orders. And you can abolish the president can abolish a previous executive order without agency action. So one example of that was the abolition of the year 2050 net zero greenhouse gas emission goal. That was solely a creature of an executive order that was since repealed and then or rescinded. And then another example that probably the most significant example in the environmental arena where this has had an impact is the issue of environmental justice. Most of the environmental justice program was built by executive order, and the Trump administration abolished the underlying basis for the environmental justice program such that the agencies don't have authority any longer to incorporate environmental justice into their agency actions. So, Luna, back to you.
Thank you, Deb. Thank you. I appreciate that. So now I'd like to turn our focus to the political and the legislative and policy implications of these executive orders. And, very timely as we sit here, the Florida legislature is in session. And Governor DeSantis has made environmental policy a hallmark of his administration. So Alex, I'd like to turn this over to you and have you give us your perspective on how these executive orders might be changing, the legislative landscape and environmental policy here in Florida.
Thanks, Luna. As Luna mentioned, we are currently in the midst of the Florida legislative session. Florida's legislature meets once a year for 60 days, alternating between starting in January through March and the following year, March to May. So we are set to conclude session on May 2nd if everything goes according to plan. As to the content of this webinar, the goodwill that Florida had experienced during Trump's first term in office is not really the case during the current presidential administration. There has been many public disagreements and animosity between DeSantis and Trump, which positions us for an interesting few years here in Florida. In some policy areas, like immigration, we're seeing DeSantis try to get ahead of the president's agenda, and in others, like domestic energy, I think we'll likely see direct opposition here. As policy proposals move forward, I think we will see these two administrations try to one-up and outdo each other, and particularly in the environmental policy arena. There's also some areas where we're seeing a parroting of federal policies, such as with government efficiency and DOGE. Following Trump's establishment of DOGE, Governor DeSantis established a state DOGE on February 24th, which will work to further eliminate waste within state government, save taxpayers money, and ensure accountability in Florida. Many of these tasks will be accomplished by conducting audits on local government, higher education institutions, and state agencies. They've also announced that they're going to utilize AI and new technologies to help identify waste and non-compliance. Some of these actions include the abolishment of over 70 boards and commissions that they deem are no longer necessary. And then they're doing deep dives into higher education institutions and state agencies to try to identify ways that they can cut back on unnecessary spending and eliminate bureaucracy. And the result of that would be the return of unused or surplus state and federal dollars that they've identified. There are also areas where I anticipate we're going to see Florida gain authority and autonomy on previous federal policy. While Florida is unlikely to adopt new environmental regulations on topics like greenhouse gas emissions or environmental justice, there are some areas where we may see Florida step in to establish new standards or regulations for policy that was previously held at the federal level. Some examples of this would be PFAS and wastewater. This was one of the rules that was clawed back by some of the executive orders that we've talked about. But there was also a bill during last year's legislative session here in Florida that would have created standards and regulations surrounding the levels of PFAS in wastewater. That bill was ultimately not passed under the understanding that the EPA rulemaking was nearing completion and that would supersede any state regulation. But given the clawback, I would not be surprised if we see regulations next year to establish those standards, as that's something that's been of a focus over the past few years here in Florida. We're also seeing a lot of talk on geoengineering and weather modification. There's a bill that's currently moving through the legislature this year that would ban geoengineering and weather modification. It's kind of become known as the chemtrail bill, as a lot of the public testimony that has been shared about this has been focused specifically on chemtrails or contrails. But it would also impact cloud seeding and other weather innovations that have been raised in the market. Recently, RFK actually tweeted support for the Florida bill through the process and thanked the governor and the legislature for moving this bill forward. So we're seeing some overlapping there between state and federal levels. We're also seeing on the 404 permitting side, Jessica Kramer, who was most recently the Deputy Secretary of Regulatory Programs at DEP, has just moved back to the EPA, working directly in the programs where 404 is handled. I believe her Senate confirmation is actually this week. Given her knowledge of Florida's assumption of this program now being back on the EPA side, I think it's likely to bode well for Florida's desire to reassume that program. Lastly, there are some areas where I think Florida is going to end up at direct odds with the priorities of this presidential administration. Governor DeSantis has been a vocal opponent of fracking and offshore drilling in Florida. However, President Trump has an entire executive order to prioritize domestic fossil fuel production and streamline permitting. This is likely to revive offshore drilling debates in Florida, and as discussed, is conflicting with President Biden's 2025 ban on new oil and gas leases off Florida's coast. This may cause federal-state tensions to rise as Florida's tourism-driven economy relies heavily on its pristine coastal ecosystems. Another example is in the resiliency arena. Resiliency has been a significant focus in Florida from both a policy and funding standpoint. And if there is a shift in focus away from climate-based policies, this could create some opposition between the federal government and Florida, as we have created policy and funding to heavily address those issues here at home. Ultimately, the final impact on Florida from these changes remains to be seen, but with another year of Governor DeSantis' administration left and legislative leaders beginning to discuss their intent to focus on environmental policy in next year's legislative session, we certainly have more policy coming our way. As we start shifting into campaign mode for the next governor's race here in Florida, I think we're going to start to see the announcement of new policy priorities from candidates, while also seeing what the governor has left on the table that he'd like to accomplish before leaving office next year. So we'll have to stay tuned.
Thank you, Alex. I appreciate that. Well, I was monitoring the questions that were coming in from our attendees, and a couple of them you touched on, Alex, but I will pose them now and see if there was anything else you wanted to add. One of our questions was whether EPA is now supportive of the 404 assumption program, and can we anticipate Florida implementing the 404 again in Florida? And can we anticipate DEP implementing the 404 again in Florida?
I'll let Debbie jump in on the legal side, but my initial take is that given Florida assumed the program initially under the prior Trump administration, I think there is some baseline level that they would be supportive of repeating those actions again. And I certainly know that it's Florida's intention of seeking to regain that authority.
Yeah, and I'll just add, of course, the 404 assumption is the subject of litigation. It's being briefed on appeal, I think through May, and you know, a lot of that would turn on the judge's decision in that litigation. And there's also, I had learned that there's a bill filed in Congress to potentially make the 404 assumption, you know, more avoid whatever the decision is, I guess, out of that appellate court as far as the Endangered Species Act, to make that more clear through Congress.
Thank you. A couple other questions here that are coming in, but one I had, Alex, to follow up on the state, Florida's version of DOGE. Are you, since you're there up in Tallahassee and in the midst of everything, are you starting to see any impact on legislative priorities from the state DOGE and any impacts on budget?
We haven't quite yet seen any impacts on budget. The budget process we will enter into on the state level here in the next few weeks. It's the one constitutional requirement that the legislature must complete during session. But from a DOGE perspective, last I had heard was that Bay County was the first and so far only county to voluntarily request one of these local audits to help identify additional areas where they may be able to cut back or return funds. The governor has done a fair amount of press and social media to try to encourage local governments to engage and request these audits. And I think some of the work on the higher education and state agency front, we're not going to hear about as publicly because they're happening within the walls of those agencies and probably not the types of things in the midst that they want to tout. But as we get closer towards the end of session, I do think that we're going to start seeing some information come out because any of those savings may be available for additional budgetary needs here in the state. And I don't think that they're going to want to miss the opportunity to tout those savings publicly.
Perfect. Deb, did you have anything else to add? Okay.
No,
Bill?
I'll stay out of that one.
That's a hot topic. Okay, so looking at some of the other questions that are coming in, and thank you all for participating. These are great questions. One I think we touched on already, so maybe I'll open it up to the panel and see if you want to elaborate, is whether the Corps has to immediately start to follow the new definition and the guidance in the new WOTUS guidance memo that we have been discussing.
I'll take that one. Yes, the Corps should be following the guidance issued. It is issued by EPA and the Corps, so that's the policy now. So if anybody is experiencing, pushback or needing to take a different look at a position that maybe the Corps in Jacksonville took prior to the guidance memo being published, it's probably the right time to take a fresh look at your status of your wetland jurisdictional determination and see if any of those discrete features might be needing a second look.
Mm-hmm. Thank you, Deb. And there was a second part to that question, just asking to elaborate a little bit more on the new definition that was in the guidance memo.
Yeah, glad to. So there had been, previous, I guess, case-by-case ad hoc guidance memos that were being published on the EPA and Corps website that, and also a training document that specifically said that discrete features like non-jurisdictional ditches, swales, pipes, culverts could be used to establish a continuous surface connection, which is the requirement in SACIT for an adjacent wetland. An adjacent wetland must have a continuous surface connection to a waters of the United States. So those previous guidance and training materials were saying that a non-jurisdictional discrete feature could establish that continuous surface connection. And this guidance memo rescinds all that previous guidance and makes it clear that no, a discrete feature will not establish that adjacency or that continuous surface connection. Now, the agencies, so they have the guidance memo, but they've also published that Federal Register notice where the final response to SCOTUS, they're looking for stakeholder input to define a few more of the terms that came out of the SACIT case to try to put a durable solution into rule rather than just rely on the guidance memo.
Thank you. All right, here's another question, a slightly different take on the issue regarding the new WOTUS guidance. This question is focusing on whether there's a way to continue a Section 7 consultation through the Corps and the Fish and Wildlife Service, presumably, under this new guidance, and if the wetlands are not jurisdictional, or this, Laura asks that the Fort Myers Regulatory Office indicated they could submit a PJD form and give the Corps jurisdiction. So I think this question is starting to come up a lot on projects that may not have jurisdictional wetlands now due to the new guidance, but maybe still have species issues that they need to address. And, Phil, Debbie, and I have handled a lot of this for clients over the years, and I'll just open it up and see if you have any general thoughts, knowing that this is still, we're navigating new territory here.
Yeah, I think, I think if listed species issues still needed to be addressed, using the Section 7 process is clearly a more expeditious process than a Section 10 habitat conservation plan. Things to look at might be whether some of the species effect determination keys or some type of technical assistance for like a may affect not likely to adversely affect determination could be available as a way to address listed species concerns short of a full Section 7 consultation. So that's very much a case-by-case basis, but I think I guess we haven't seen it all play out, how the guidance memo will be interpreted or applied by the agencies, but I suspect that if a project is in the process conceding jurisdiction, that those PJDs can be used to wrap up a project, and that you're not required to do that second look that we were just discussing about the discrete features.
Yeah, I agree with that. And I think in the past, we have tried to work when there aren't jurisdictional wetlands. We try to work directly with the service as much as we can to try to get feedback through the technical assistance on the level of impact. But it really is going to depend on the fact-specific situation with the listed species, if you think you can make a no effect or a MANLA determination versus if you've got something a little bit more serious. Okay, another question here in the chat, and Alex, you may have touched on this, so I'll see if you want to elaborate. Mark is asking if any of the executive orders have affected the PFAS cleanup requirements or rules. And I know you just touched on that a little bit from the state legislative perspective.
So there was a bill a couple of years ago that actually prevented DEP from taking any action prior to the adoption and passage of the EPA's PFAS cleanup levels. So we had kind of been in a little bit of a holding pattern here, waiting for that rulemaking to make its way through the end process. I think on the wastewater side, we're definitely seeing these impacts because I think everyone was kind of gearing up to be able to start meeting those levels, or at least knowing what that was going to look like. And now with that clawback, I think there's a bit of a question mark there. On the drinking water side, there's not as much of a question. And I know from speaking with some utilities, you know, they're planning to move forward with starting to meet those 4 parts per trillion level that was established. But I think we've got more that needs to be addressed to really set the scene on the effluent and wastewater side.
Thank you.
And I'll just jump in. I think we can expect some initiation of rulemaking for groundwater cleanup target levels and soil cleanup target levels, but I think it might be a slower process than some might like, just trying to gather all the support for those types of levels and I mean the scientific support to adopt those rules in Florida, just since that January 2025 deadline has since come and gone. Also, I think it's a little bit unclear what the Trump administration's policy on PFAS is going to be. Seeing some, you know, media reports that it hasn't really been determined yet until they get a person who's going to be in charge of that program. So.
Thank you. Another question we have here is, what exactly is the status of the delegation of the core permitting to the DEP in the interim? I think we've touched on some of this already. Anything else to add?
The status is all 404 permitting is back with the Corps. Yeah.
Okay. Another question. Do we know or what are our thoughts on the delay to listing the tricolored bat by the service? And is this possibly associated with the Trump executive orders? And I'll just start that, you know, I believe the bat may be the tricolored bat, a candidate species, but we've seen sometimes a lot of delays in getting species listed for a variety of reasons, like science, public comment, just resources at the service itself, and also probably with the change in administration, there's been some slowing down of regulations we've just seen in general, but I'll open it up to the panel and see if there's any other thoughts on the listing delay.
Yeah, thanks, Lynna. I don't have any inside baseball on that listing delay. I think, you know, I'm trying to recall the status, but I think it was a proposed listing and it, you know, has a significant effect across the country. It has a very wide range, so probably something that'll be under consideration in the change of administration.
Mm-hmm. And we've sometimes seen species that remain on that proposed list for years before they are ever listed, and sometimes they're just not. So thank you for that. Okay, I see another question here. This one's from Jerry Ward. He's asking, what can the public do? Maybe this is like a practical tips question. What can the public do in helping get the government to implement and do different actions in light of some of this uncertainty that we're seeing with the executive orders?
I can take a stab at that. So, I mean, you have elected officials and that you are the constituents of, and I think not just for these issues, but in general, reaching out to their offices and as best you can establishing relationships with your members and their staff pays dividends. Being able to reach out to them when there are issues of importance to your industry, to your area, really does make a difference. I have previously worked as a legislative aide in both the Florida House and Florida Senate, and getting those calls or emails from people that were knowledgeable about a topic that were in our area were some of the most impactful outreach that we received during our time in the legislature. So be it on a state level or a federal level, finding out who your members are and how you can get in contact with them. And there's several places on the websites that you can kind of enter in your address, and it'll list every state and congressional member that represents you, is really, I think, the best place to start.
I would just add on to that, we said throughout, many of the policies in these executive orders are going to require formal rulemaking process, either to revise existing rules or rescind regulations. So to the extent that you're impacted by those actions, that process is designed to engage the public and allow for public input through the notice and comment process.
Thank you, Phil. Looks like we're getting a lot of questions on the WOTUS and the guidance memo. Here's another question, slightly different, from Jennifer. Apparently the Corps has stated that they will still utilize culvert connections based on the one wetland memo, and she cites the reference memo. I won't read that. And she's asking if this approach is applicable here in Florida.
I would have to dig in. I don't know the answer to that. I mean, I'm actually trying to understand the facts. Like, if there was an adjacent wetland and it's separated by a culvert, are they like continuing to delineate the same wetland beyond the culvert? I'm not sure. Or like some of these features, maybe they get delineated as part of a wetland, if that's the question. And I think that the guidance memo doesn't directly address that.
Yeah, I agree. I'm also, we would need to take a look at the memo that's referenced, and maybe that's something we can get back to the attendee on offline.
Yeah, I'd like to do that. Thanks.
Yeah. Okay. Here's a question regarding environmental justice. The panel has used the term environmental justice several times, and it's Ron Edenfield. He's asking if this is a legally defined term, or has it become just a pronoun or maybe a term of art in current lexicon?
Yeah, gosh, I don't know if it's a defined term. Maybe Phil, you can help me out. But my thought was it all stemmed from that Clinton administration executive order, and the term may be defined in that executive order. I don't know if you have thoughts, Phil.
Yeah, and most of the policies since that executive order have been grounded in that and other executive orders. Now, as we said, with the rescission of those executive orders, those policies are now, vulnerable. There was an effort to justify some environmental justice policies and regulations in, I believe it was Title VII of the Civil Rights Act. A court did overturn those, and so that kind of only leaves the executive orders as the legal basis for all of the environmental justice policies that we've seen. So again, with those environmental order or executive orders going away, environmental justice, however it is defined, does not have a firm legal foundation.
Thank you, Phil. And I'll also add, not that this is, quote, the legal definition, but we do and have seen, we'll see how this changes, but we've seen environmental justice as a section in a lot of federal NEPA analyses. So when you look at an EIS, there'll be a section there in the environmental justice, and it's a lot of the socioeconomic components. It could be very broad, but those types of documents coming out of the federal government in the past few years have had a lot of details on what that term means to them in that context.
Mm-hmm.
Another PFAS question.
Luna, I lost your sound a little bit there.
Oh,
I don't know
okay.
if you asked a question.
I was just looking through the the question box here, excuse me, to see if there was anything left. We've just got like a minute or two for another question. Looks like there's another question here from Mallory. As long as the ditch swale meets the relatively permanent standard, they can claim a wetland regardless of how many discrete features. Not sure if this is a question or
I think
just
that's a comment in response. Yeah.
Perfect. Okay, thank you for that. And another question, maybe this was already addressed, asking regarding the Corps in the last 2 weeks, since the guidance memo has indicated they're utilizing the pre-2015 definition. Can you give any update on when there will be more clarity with the memo and its interpretations?
Yeah, I think that's going to be need to be forced on a case-by-case basis for if you want it applied to your project. You'll have to probably, what we would recommend is getting together with your environmental consultant, going over, you know, what's the source of the jurisdictional claim? Are there discrete features that, you know, need to be analyzed to see whether they sever jurisdiction? But otherwise, you know, you have the memo. The next step is going to be the effort by EPA and the Corps to do further rulemaking. We do have the court case that stayed the conforming rule and the 2023 Biden rule. So that is correct that the pre-2015 regime applies here in Florida. And I think there's been some, Phil, maybe you can help me out here. I think there's been some stays in those court cases while this administration tries to figure out the new policy there too.
That's right.
Thank you all. Well, we are reaching the end of our webinar, and I want to thank all of you for joining us, and join me in thanking our panel. I appreciate all the insight that you guys have brought. It was a great discussion today. Just a couple of points. You know, if you do have any additional questions of us, feel free to reach out. We're happy to chat with you offline. You know, I think what we're learning is, you know, as I said before, this is a bit of uncharted territory as these things play out at the federal level and the state level. We'll start to know more. And a lot of these questions that you're asking are questions that all of us on the panel are receiving from our clients. So we're all on the same track here. And also, if you enjoyed this webinar, I think our practice group is going to continue to do these webinars on a periodic basis. Maybe the next one's going to be more focused on WOTUS. Credit. So we'll go ahead and be sending a certificate out to all of the attendees that made it through the panel. So thank you all very much for attending, and enjoy the rest of your day.